Your Honors, may it please the court. My name is Ryan Oliver, the appellant appearing pro se. I would like to reserve 5 minutes for rebuttal if I may.
You got it.
This appeal arises from a trial court's erroneous modification of a time-sharing order. I'm asking today that this court vacate the October 2024 supplemental final judgment and reinstate the October 30th, 2022 amended final judgment. I'm going to address 4 primary issues today, if I may. First would be the ignored expert testimony that's reviewed under the abuse of discretion standard, followed by substantial change and the best interest, also reviewed for abuse of discretion, and then the due process issue reviewed de novo, and time permitting the cumulative effect reviewed de novo. The 5th issue that you'll find in my initial brief is a child support issue. It is a relatively minor considering the other issues at play. I'm going to rely on my brief for that particular issue unless I need to rebut anything. So starting off with the ignored expert testimony, I feel as though the trial court abuses discretion by ignoring Dr. Krongold's unrebutted testimony without explanation. I rely heavily on EL versus AL, case heard in this court, 2023. The court determined in that situation that the trial court must give reasonable explanation when ignoring unrebutted expert testimony, and that's pretty much what we have in this case. Dr. Krongold, the mother, was ordered in a final judgment to undergo a psychological evaluation. Dr. Krongold conducted that evaluation, and during his evaluation, he identified, while conducting interviews with the mother, that her insight and decision-making were significantly impaired. He identified chronic substance abuse issues, relapses during pregnancy, as well as relapses during the course of this case specifically. He made a number of diagnoses, and in determining the best interest factors, particularly the mental health element, the court found that that element was neutral, despite there being no mental health concerns or arguments pertaining to me. And Dr. Krongold's report identifying that his report was consistent with, I believe it was 7 previous psychological evaluations that identified credibility issues with the mother, and that went unrecognized. The answer brief really relies on Dr. Krongold not being called to testify at the final hearing. I believe they cite a hearsay hearsay exception in 90.804, the declarant unavailable. I would point to the fact that the testimony of Dr. Krongold, as well as his report, were admitted into evidence at the final hearing in May of 2024 without objection. So that testimony was admitted. The opposing counsel had already been given the opportunity to cross-examine or conduct a direct examination of Dr. Krongold in the October 2023 hearing. They also argue in the answer that Dr. Krongold's report is stale. And I believe staleness cuts both ways. Dr. Krongold identified that the mother suffers from a chronic, pervasive personality disorders that impact every aspect of life. I believe the fact that it's chronic makes currency irrelevant. If the mother felt like that report wasn't correct or wasn't accurate, the mother should have called another expert to testify as to her current mental health state, rather than the court relying strictly on the mother's self-serving testimony that Dr. Krongold had already determined she was not credible. On issue 2 that I bring up today, the substantial change, the court seemed to rely heavily on the mother's compliance with the amended final judgment of 2022, rather than the evidence presented to support her argument of a substantial change. One of the things I really want to point to is Dr. Krongold had recommended that the mother undergo weekly mental health sessions or therapy sessions. Over the 20 months, I think that equates to about 81 sessions if done weekly. through the mother's testimony, as well as through evidence that the mother introduced, she only participated in six total therapy sessions in approximately 20 months. And then I think very importantly is that during her testimony, the mother was asked if she used drugs prior to the final judgment, which she stated no in trial, and asked if she was using drugs now. Again, she stated no, and was asked if that constituted a substantial change, and she stated no. I'll go back again to Dr. Krongel's report that identifies the mother's credibility issues in that in her self-reporting information provided to Dr. Krongel, she acknowledged an extensive history of drug use that spanned over a decade with multiple relapses throughout that time period. But when we get into trial court, all of a sudden that is gone and there is no drug history prior and there is no drug history now. I'm not sure that that reaches the level of a substantial change. The answer brief seems to shift the burden of proof to me that a modification is not in the children's best interest. I believe that misstates the statute. The 50-50 is just a starting point. And I believe, under Wade v. Hirschman, there's the two-prong approach. We've got to have the substantial change to open the door, and then the best interest factors to allow that change to actually take place. I believe we fail to meet, or the mother fails to meet, the first prong under Wade v. Hirschman by not identifying or at least providing substantial and competent evidence to support that a substantial change has in fact taken place. Now, in my initial brief, I argue stare decisis, I believe, is issue number 5 in my initial brief. I believe it's probably better presented as a best interest argument using Hamilton as a guiding in that particular issue. There we have Miss Hamilton, who has acknowledged substance abuse issues. She sought treatment and apparently overcame her substance abuse. Here, in this case, the mother denies ever having it, refuses to seek any treatment that is recommended by her elected professional. In Hamilton, this court found that overcoming substance abuse may be a substantial change. And in the mother's answer, they essentially say that my position would mean that a mother or a parent, for that matter, would never get their child back. It would be in perpetuity if they couldn't, even if they overcame substance abuse issues. That's not the position I hold. I believe very much that a parent can overcome substance abuse, and that's very much in line with what this court has previously held. What I suggest is that the mother's evidence doesn't support that she's had put forth a meaningful effort to overcome her substance abuse.
She continues. Have negative drug tests for 20 months.
I'm sorry?
Trial court found she'd had negative drug tests for 20 months. Is that not correct?
She presented negative drug tests, and there was a significant gap in between a portion of those drug tests. The date from first to last does span 20 months, but I believe it's
and if all the test results in that period were negative?
No, Your Honor, there were not. There was actually one test that was inconclusive. And during about a 6-month time period where the mother went untested, she conducted a talking parents call with the children, which is part of the final judgment, where she acknowledges in a recorded call that she is so drunk while communicating with kids. This is also taking place while we're not seeing any drug tests occurring. But I think what we see, I relied on my stare decisis argument in Hamilton relied heavily on, that the court found that the mother in Hamilton had been clean for 20 months approximately. I believe it was exactly 20 months, just like they did in this case. But because of the pattern of relapses, which is the mother's self-reporting factor that's included in Dr. Cromwell's report, that it wasn't in the best interest. In Hamilton, as in this case, you're kind of placing, in this instance, a 4- and 5-year-old in a position to recognize the dangers presented by the mother's substance abuse and her denial of self-reported substance abuse. I think a big distinction between the two cases are that Hamilton acknowledges that she had issues and she sought to resolve those issues. We don't find that in the immediate case. And I find it interesting that in the mother's answer, there's no mention of Hamilton. They make no effort to distinguish the instant case from Hamilton. The next issue I'll move to is the due process issue. In the October 2023 hearing, it was very lopsided. The mother was given an opportunity to present her case in chief, whereas I was not at all provided the opportunity to present any evidence, call witnesses. You can see that by looking at the trial transcript. I think it's page 3 of the trial transcript, where it talks about the evidence that's been introduced. It's all the respondents. Now, you'll also note that reviewing that transcript that the trial judge mentioned a number of times that he had to go, running short on time, he has a family engagement, we've got to move. That is very similar to what we see in Stamler, a case that this court decided.
Did counsel ask for a continuance of the hearing?
No, Your Honor, there was no continuance request.
Try my question. Did anyone ask for a continuance?
No, no.
And one follow-up for that, did your lawyer ever said, Judge, we have witnesses that we like to present? It dovetails with the question about whether or not there's a continuance. Was that mentioned to the judge before he?
In fact, it was at, I believe it's about the 10-minute remaining in the hearing. My trial attorney mentioned, when the judge says we got to hurry, we got 10 minutes left. My trial attorney mentioned at that point, well, I still need to call my client. I still need to put on my case. There was no formal request, but that is also something that you see in Stamler. There was no formal request in Stamler for a continuance, but this court held just in April of this year that was enough to preserve that error in due process. And so we see a very similar situation in this case that we see in Stamler with regards to no formal request for a continuance, but there was
Stamler, if I recall the facts correctly, twice the attorney said, Judge, we have to get to, I forget who it was that they were trying to get to, but it was brought up twice, and I did not read it. I did not read the facts that are recorded in that case as being quite the same as how this played out in the transcript. I got the impression that the hearing was probably set for too short of a time, that they weren't going to have time to get through everybody that they wanted to get through. And what happens in these things is you kind of got a fork in the road. You either got to ask for, Judge, can we carry this over to, let's get 30 more minutes on your Honor's hearing time, or an hour, whatever. Or you make the strategic decision, Judge, can we submit written closing arguments and we'll just go with what we got. And that's a strategic decision. That kind of thing happens.
I understand, and I think it's kind of misleading reading the actual transcript versus being in the trial court when that happened. But I can tell you,
I hear you.
I can tell you that in that exchange between my trial attorney and the judge, there was a question: Are we continuing? And that was a question. It doesn't appear as a question in the transcript, but the trial judge responded, "No, I'm ruling today." So there was already a question as to whether or not there was no formal request. And you may be right, Your Honor, in the differences between Stamler and how many times. I would suggest in my case there was twice. I can only go based on the decision in Stamler, where I read that the husband's counsel states, but my client hadn't even testified yet. It only appears once in the decision.
I mean, I'll tell you what we would like to see. What we would like to see is, Judge, respectfully, I object to you ruling today. We've got witnesses. We respectfully request to continue. That's what we would like to see, because then it's nice and crystal clear.
Right.
We don't always get that, but it is what it is.
I
understand there are. I understand there are.
I don't disagree with that, whatsoever. But taking the position that the opportunity the meaningful opportunity to be heard, even if it was within 10 minutes, it wouldn't have been meaningful. The trial court relied very heavily on a contempt finding that happened as a result, or that happened, related to that October 23 temporary order. It's found in the best interest factors. In fact, it's factor A, where the trial court says, they found that I wasn't willing to compromise or be agreeable to a temporary modification, and they cited that contempt finding. Now, we did file, the other thing the mother's answer suggests, and it's a couple times that they do this, that that this error wasn't preserved to be heard in front of the court today. A motion to vacate was filed under 12540B, I believe it is, in February of 2024. That was actually heard at the final hearing. During that, if you review the transcript, you'll notice that the trial judge never says that your due process, rights were violated. He simply says, I'm not sure that I can grant the relief that you're requesting in terms of vacating the contempt motion and then the underlying temporary order. He says, if you'll bring back something to convince me, the case law was within the motion to vacate that supported his ability and authority to do what was being requested in relief. And it was also reiterated in a motion for rehearing that I filed, I believe it was November of 2024. So I believe the issue is properly preserved.
Judge says.
Weren't you just telling us there wasn't a ruling?
No, in October of 2023, there was a temporary hearing. There was a ruling, and I believe that ruling and that judgment that followed is void because at no point during that hearing.
No, on the motion to vacate, I'm sorry.
The motion to vacate, the judge denied the motion to vacate, stating that he did not feel he had the authority to grant the relief that was requested.
I'll let you go over a little bit, so unless you want to just go into your rebuttal time, it's up to you.
No, I'll rest and reserve for rebuttal.
Okay.
Thank you.
Good morning, Your Honors. May it please the court. My name is Allison Perry, and I represent the appellee, the mother in this matter, Cassie.
Ms. Perry, before we get into your argument, one thing that troubled me is the actual final judgment. I don't know if you read closely. There's some language in there that was rather unprofessional.
Yes,
It was disturbing to read that.
yes, I agree, Your Honor.
I don't know. I hope it's not intentional, but language like that really should not be found.
Absolutely.
In final judgment.
I absolutely agree with you.
All right.
So,
In the spirit of that, can we also, Mr. Oliver said he was going to allow his brief, the issue about child support and the income determination in paragraph 12 of the supplemental final judgment. Insofar as there's an undifferentiated total sum of $4,635 there that appears to include public assistance
right,
as part of it. You can see that's
that's a no-no, but it was not significant enough for us to bring a cross appeal.
oh no, I'm not, and that's I'm asking, would y'all concede that's an error here?
Yeah, yes, but I don't think it's I don't think it's that material when you.
Okay, but if I'm the one paying it, depending on who's got to pay it, I mean, it may or may not be material. It's in the brief. I'm looking at it. It's 6132B2E. Says what it says and looks like that error. So I appreciate the candor on that.
Okay, Your Honor. Any other questions right now? Okay, I'd like to first disagree with the father that the mother's only had 6 counseling sessions. All the testimony and evidence is that she got in as soon as she could. It did take a few months before she could get in to see a therapist because of the scheduling. And but she went to approximately 15 therapy sessions. The judge found that she substantially complied with Dr. Krungold and the guardian ad litem's recommendations. And this is competent substantial evidence because the record shows she had 20 clean drug screens and 24 clean drug screens in a 20-month period. And that is what they wanted. They agreed that when the mother tested positive, that she would not have unsupervised visitation with the children. She agreed to that. It's just like the Tudler case that I rely on. And that's a 4th DCA case. And in that case, the father tested positive for drugs. And he also agreed that the mother would have 100% time sharing and he would have supervised visitation. And after 2 years of being in therapy and not having positive drug tests, the father was reunited with his children and time sharing was changed. And that's exactly what happened in this case. So, let me see. There were also mental health concerns with the father. So that was incorrect because he was also ordered to get therapy for sex addiction and other things. So that was also incorrect. Also at the hearing in October of 2022, there was no proffer of any evidence that what the father wanted to present to the court. And the court he could have done that after the judge left the bench. And he did not do that. This mother has shown dedication to getting clean and sober so she can be with her children. And so those children can also be with their half sister, who is a couple of years older than they are. I'd like to remind the court that the standard of review, of course, is abuse of discretion, which means that you'd have to find no reasonable person would have ruled the way the court ruled. And if you read in the brief, I quote what the judge said, his reasoning for finding it was a substantial change in circumstances was, it was the basis of her being removed was her drug use. That has been removed, so she should be reunited with her children. I ask the court to affirm this, and that's all I have, unless you have any questions.
You.
Thank you.
Mr. Oliver, I'll give you your full 5 minutes.
Thank you, Your Honor. As in the answer brief, it appears that the mother is arguing, or at least counsel today is arguing, that this is an isolated incident and that the removal of the kids back in August 22.
I didn't hear that argument.
In her answer brief, it's on.
I do have a question for you.
Yes, sure.
You didn't want to get into the child support issue much, but I didn't really. I couldn't tell from your brief why you were raising it or how you were agreeing by it. Could you detail that for me, maybe?
Yes, Your Honor. In fact, it's an error that's beneficial to the mother, and I recognize that. But I brought it up in my brief to underscore the number of errors. There were errors all throughout this entire proceeding.
I mean, to Judge Kelly's point, you want to pay more in child support? I mean.
Well, to be fair, Your Honor, if it's reversed and remanded to the trial court for further proceedings on child support, there will be additional testimony forensic. So the mother's financial affidavit is not correct. She's got deposits of $12,000 to $20,000 per month.
So what you want is on remand, just open the whole thing up to a whole new evidentiary here.
For child support, yes.
Oh,
Yeah, absolutely.
now I understand.
Right.
Yeah, because I was lost.
And Judge Kazami, you mentioned the unprofessional language, and quite honestly, I was going to try to avoid that. But I think if we look to another case that this court decided earlier this year, I think it was Washington v. Perzov recoveries in April, adoption of a verbatim order that doesn't reflect thoughtful analysis of the facts by the trial judge is alone reversible error.
So these were orders submitted by the parties?
No, Your Honor. The supplemental final judgment that's under review today was submitted by an attorney. And I can't specifically say which one because I'm not in that process of the client to submit orders to the court. So I don't know who wrote the final draft or who submitted that proposed order.
Was that one of your issues on appeal, is that the trial court improperly adopted verbatim an order submitted by counsel, and you didn't have an opportunity to object?
I I don't know who submitted, so I don't know if an objection would have been appropriate. I didn't see it. I never recognized that.
So we don't know how that happened.
I don't know how that happened.
Okay.
An attorney submitted it. I don't know which one is my presumption, but I can't speak smartly as to which one. But as far as Tullier, I want to distinguish that case. Counsel suggests that they're similar. Just as in Hamilton, in Tullier, we have a father who recognizes that he has substance abuse issues. He seeks therapy in a meaningful way, seems to overcome it. Here, even if we accept that the mother participated in 15 therapy sessions, Dr. Krongold was clear. It requires weekly, and personality disorders are chronic, pervasive, and impact every aspect of life. They're generally incurable, they're treatable, but not curable. What we see with the drug use is a symptom of the underlying mental health issue. Without complete resolution of the mental health issue, we can't be confident that the substance abuse issue has been resolved. And that was the purpose behind ordering Ms. Mez to have that psychological evaluation, was to determine whether or not, in the event of supplemental final judgment or a supplemental petition to modify, if she had resolved the issues that led to the substance abuse to begin with. I'm going to close and simply saying this appeal today is not simply about reweighing all of the evidence. What I'm asking is that this court consider the bedrock safeguards, due process, following the statutory requirements for the findings of fact like we see in the child support, that the appellee and the trial court seem to ask this court to overlook. When those safeguards are applied, I believe every contested issue in my appeal tilts towards reversal of the supplemental final judgment and reinstatement of the August 30th amended final judgment. So I ask you to vacate once again the supplemental final judgment and reinstate the August 30th order. Thank you.
Thank you both. That's our last case. We are adjourned.
All rise.